So Colorado, a victim has a right to be heard at any court proceeding. Any court proceeding. I'm thinking water court. What about water court? What if you go to a drug court and you're sitting there talking about an assault? It seems like, according to the rules of evidence, or according to the victim's rights statutes, the right to be heard at any court proceeding. So if you're a victim or alleged victim, if you filed criminal charges, then you have a right to be heard at any court proceeding. The county court, district court, water court, any and all courts. You probably should be in the court that is supposed to be at, but if there's an emergency, that would be important, right? Just get to the courthouse and just say, I want to talk to the judge. There was a crime. I want to report it directly to the judge. And then let them, let him swear them in or whatever. The right to not be harassed, intimidated, or abused. The right to consult with prosecution after a victim has been charged. Consult with the prosecution, the victim, after the alleged culprit has been charged, prior to a disposition and prior to the trial of a case. The right to be informed by the local police, the sheriff, and his deputies of the status of the case and the time of the next court appearance and other scheduling information and needs. That makes sense, right? You're the alleged victim. Hey, what time is court? Oh, it's 6 o'clock in the evening. Oh, okay. That doesn't sound right to me, but if you say so. The right to consult prosecution, the right to not be harassed, intimidated, or abused, the right to be heard at any court proceeding, the right to be informed of and present for all critical stages of the criminal justice process. Now, this is interesting because it actually says criminal justice process, criminal justice system, critical stages. So we're talking about stages of the criminal justice process, i.e. system. And then they talk about, 24, 4.1, 302, 2A, 2A5, 2A7, 2E5, 2K3, and on and on and on. The right to be informed and present for the critical stages, and they describe some other ones without having to submit a written request. So what are the critical stages of the criminal justice system? Here in Colorado, you had that 10-step procedure by the Right Law Group, which has been, a pretty good, like Newton, it's a good, rule of thumb. But let's actually read 24, 4.1, 302. What does that say? 24, 4.1, 302 -2. So we have a right to be informed of and present at the filing of charges, and informed of and present at the sentencing or resentencing hearing. We, the alleged victims, have a right to be informed about and present for the diversionary agreement or the preliminary hearing or the disposition or the sentence or resentencing hearing, the filing of the charges. The defense gets to ask tough questions at the preliminary hearing. Also, any bond hearing, whether it's initial, modification, reduction, or removal. The arraignment, guilty or not guilty, nolo contendere. The alleged victim can be at the arraignment, the bond hearings, the preliminary hearings, diversionary agreement hearings, disposition, the motions hearing, the evidentiary hearing, the status hearing, the pretrial readiness conference hearing, any subpoena or application for alleged victims' education, compensation, mental health, medical history, or other privileged records. CRS 13-9107, CRS 13-9107. The trial, the sentencing hearing, the right to write a victim impact statement and to give an oral statement on top of the written victim impact statement. The DA has to give you a written impact statement form so you can fill out the form. You could just write it on a piece of paper too. But you could turn in a written victim impact statement and then give, 1 minute oral statement. Any subpoena or application for the alleged victim's education, compensation, mental health, medical history, other privileged records. The appellate review. The appellate decision, petition for expungement, modification of the no contact provision of the mandatory criminal protection under the section 18-1-1001 CRS or section 19-2-707 CRS. Hearing, the appeal review or decision. So the victim gets to know about the appeal and they get to be present at the appeal. They get to know about the appeal and the review and the decision and the expungement, modification of the criminal protection order under 18-1001. they get to go to those hearings. They get to know about those hearings. They get to go to those hearings. They can call the sheriff and the deputies. They can say what time the hearings are. They have a right to consult with the prosecution about those hearings. Now, there's a way in victims' rights for the alleged victim to be heard in court without being physically present in order to provide input to the court beyond a written victim impact statement. There's more that the alleged victim can do. And if they need to be at court to testify this or that, also be around your phone, because I saw DA Engel was able to text an alleged victim right there in court. So they're trying to work out a deal. One person says something, text the person, they agree to it. You could also just call them on the phone. You could email them, Twitter, Facebook, YouTube. There's a whole bunch of ways we could contact each other. Handwritten notes, hand-delivered notes, U.S. mail. That's pretty much all of them, right? Text and phone call, email, Twitter, Facebook, YouTube, handwritten notes, hand-delivered notes, U.S. mail. The rights to be informed of the final disposition of the case. The right to be informed of being able to file a civil suit after a criminal conviction. The right to money damages, restitution in some cases. The right to receive one's property back if the police took it for evidence reasons. The right to view the pre-sentence report of the probation department. The right to view the pre-sentence report of the probation department. The right to view the pre-sentence report of the probation department. So what are victims' rights? You are to be free from intimidation, harassment, and abuse. The alleged victims are supposed to be treated with fairness, respect, and dignity. Victims are informed of the critical stages of the criminal justice process. They are informed of it. They can also be present there, and they can be heard as well. At every single, what's it say? The right to be heard at any court proceeding. The right to be heard at any court proceeding. The right to be heard at any court proceeding. A lot of times they want to say, shut up to people. Hey, you stop talking over there. Excuse me, Judge. I have a right to be heard at any court proceeding. Are you a victim? I am now. You hurt my feelings. That causes emotional distress. I'm going to sue you. Allowing the victim or the victim's designee, the alleged victim, to appear in court proceedings in person, by phone, or virtually by audio or video or similar technology. Establishing for victims the right to receive a free copy of the initial incident report from the investigating law enforcement agency that includes at a minimum the victim's name, offender's name, date of the crime, charges, and a summary of the incident. Victims' rights 24 4.1 302.5. Number 1. In order to preserve and protect a victim's rights to justice and due process, each victim of a crime has the following rights. The right to be treated with fairness, respect, dignity. Yeah, some of these are being redundant, but that's a good way to memorize them. To be free from intimidation, harassment, and abuse throughout the entire criminal justice process. To know about all the critical stages of the criminal justice process. To be informed of and present for all those stages. For a victim of a sex offense, the right to be informed of the filing of a petition by the perpetrator of the offense to terminate sex offender registration pursuant to section 1622.113.2 C CRS. The right to receive a free copy of the initial incident report from the investigating law enforcement agency, except that the release of a document associated with the investigation is at the discretion of the law enforcement agency based on the status of the case or security and safety concerns in a correctional facility, local jail, or private contract prison as defined in section 17.1.102 CRS 17.1.102. A. The right to be informed upon request by the victim when a person who is accused or convicted of a crime against the victim is released or just discharged from county jail. The right to be informed upon written requests by the victim when a person who is accused or convicted of a crime against the victim is released or discharged from custody other than county jail, is paroled, escapes from a secure or non-secure correctional facility or program, or absconds from probation or parole. The right to be heard at any court proceeding. That's D. That's D. That's the fourth one. The right to be informed about restorative justice practices as listed in 18-1-901305. 0.5. The right to be informed of financial and other community services for victims and witnesses, such as crisis intervention services. 2. victim compensation funds. 3, victim assistance resources. 4, legal resources. 5, mental health services. 6, social services. 7, medical resources. 8, rehabilitative services. And 9, financial assistance services. And 10, the right to be informed about the application process for such services. The right to be informed of the process of protecting the witness or victim if there's intimidation, abuse, and harassment by the accused or the convicted or their associates. The right to have your employment protected with employer intercession services. The right to be reassured by the prosecutor that they will aim for a swift and fair resolution. The right to keep the alleged victim's locating information, phone number, employment address private. Also, proceeding conducted by the court concerning whether to order disclosure shall be in camera. It shall be in a camera. The right to have social security numbers redacted on all documents, pieces of evidence, etc. X, the right to be notified of how to request protection of their address pursuant to the Colorado Rules of Criminal Procedure. The right to get a victim impact statement form. The right to get a victim impact statement form from the DA's office. This is all constitutional. The victim's rights is a part of the Bill of Rights of Colorado. Therefore, all of these add to the total amount of rights. We have a whole, not just a tasket Bill of Rights, but we have a whole landfill of rights. We got an entire garbage pail. I don't. Victims' rights pursuant to the U.S. and Colorado Constitution's right to be informed of how to enforce victims' rights. The right to be informed of the STD results ordered by the court. The right to know when the convicted offender has been released, escapes, or has been transferred to a less secure public or private facility, program, hospital, or jail. Right to be provided with a secure waiting area at the courthouse so the alleged victim is not seen, or to avoid at the very least being in close proximity to the alleged culprits. Right to be notified of a sealing of records hearing, so sealings, expungements. The right to be informed of a criminal protection order upon written request of the victim. The right to be notified of a referral of an offender to community corrections. Any parole application hearing and full parole board hearing, review hearing. Right to attend probation revocation hearing. The right to be informed about any complaint, summons, or warrant filed by the probation department. Change of venue or release from probation supervision. Attack on judgment or conviction hearing. The parole or release of offender from jail or hospital. The right to attend or be informed about any parole or parole revocation hearings and of any termination of sex offender registration hearings and executions. Post-conviction DNA test hearings. Preservation of DNA evidence hearing. CRS 18-1, 4142B. A tampering with evidence hearing 2431. 90223 and all other hearings. So the alleged victim gets to go to all this, just a front row seat to the entire criminal justice system. Some people think it's a legal system, and it probably is. And when I told Danny Sanchez that I was going to go the legal route, he seemed relieved. What we want is a legal system that is strong enough to counter the fucking street justice or the Hell's Devils justice or the Nazi justice. So-called fucking injustice. But we need the government to be stronger than all these other, local gangland Hell's Devils. So there you go. That's victims' rights. That's a whole bunch of victims' rights right there, and it's important. But every time that somebody calls 911, you should just have like a little business card, and you could just hand it to them because you got to read the Miranda rights too. How can you explain all this to a person unless you just give them 2 or 3 or 4 pieces of papers? Here's this, here's that, here's this. But that's really important, and it's also law. So just go through each and every one of those and try to memorize them, because if you're the alleged victim, then you get to go to the evidentiary hearing, the status hearing, the pretrial readiness conference. You get to go to the subpoena application. You get to go to the preliminary hearing, sentencing, the filing of the appeal, the trial, the impact statement. You get a whole bunch of. You get to go to, everything.